order to economize on time and try to stay on the clock, hand over to Deepak Sanan, who will then introduce the next session. As I mentioned, Deepak Sanan is an old friend of mine, somebody that we have, in a sense, had the pleasure of knowing for a large number of years. Great respect for his scholarship, his ability to migrate from being actually a very effective bureaucrat. Dr. Huck, there are bureaucrats and bureaucrats, and we are so pleased that we have two of them with us today who really do not fit into your mold of the ineffective bureaucrat. These are very effective bureaucrats, and I of course refer to my good friends Ramesh Abhishek and Deepak Sanan. Deepak Sanan was with the Himachal Garda of the IAS, and he's held senior positions of every kind possible in that state. He's also been a senior advisor at the NCAER, and we're very pleased to have him with us, and is of course consulted widely with a range of multilateral institutions. And I had the great pleasure of working with him when he was the India country team leader for the water and sanitation program of the South Asia region of the World Bank, and I was a staffer at the World Bank at that point in time. So Deepak, welcome, and please take over. Thank you.
Thank you, Shekhar. Thank you for those extremely kind words. I don't know how well-deserved those are compared to what Dr. Huck had to say about civil servants. But, but since Dr. Huck is an old friend, I'm sure he has actually very pleasant things to say about people like me and Ramesh.
I also know you, sir, of being good and very progressive in this.
Thank you. Thank you, Professor. So let me begin by very briefly introducing the first session of this really path-breaking workshop, which I think for the first time in India focuses on evidence-based, data-based research to bring out what policy can improve upon in the various spheres in which, as Dr. Huck has wonderfully in his tour de force pointed out, the various areas which need addressing in land governance. So the first session, signaling session of this workshop today is about modernizing India's land reforms. And the two papers which we have today are about litigation and how they relate to land records and the quality of land records. And the second paper touches on what are the different real critical problems which have affected the creation of modern cadastres in India, and what kind of lessons we can learn from international experience in this regard.
We're having some technical difficulties with Deepak. Deepak, go ahead, please.
To chair this session and to take it forward, I would like to introduce to all of you a very dear friend, a colleague, and someone who I've known since never together.
Deepak, we can't hear you. Ramesh, you need to unmute your microphone, and then we will just start. Ramesh?
Okay. Hi. Good evening. Thank you, Shekhar. Good to see you. Thank you, Dr. Huck, for a very illuminating talk. Having been associated with land administration for a long time, one can only agree with you on everything that you have said. Your frustration with bureaucracy is well shared. So not worry, we are on the same side. Exceptions prove the rule, but the rule, I mean, unfortunately, we are not able to do without them, and we are not able to do with them also so far. So we have to find some solution to that. It's a very important session, and thank you, Deepak, for inviting me to be part of this session. We all know that land is such an important subject, and it's a pity that in our country it's given relatively low priority. Maybe it's not a very great issue in elections, That's why somehow it is neglected by everyone. There used to be a time when administration of land was the key job of district administration. Now it seems that most people have forgotten about it. We have seen, there used to be a time when we knew that there used to be a revisional survey every 30 years in Bihar. I belong to Bihar cadre after the initial cadastral surveys. And we were all part of the various survey teams that we had. I remember having spent a lot of time in Dhanbad when a revisional survey was going on, and also in land survey in urban areas in Bhagalpur. But somehow over the period of time, low priority given to this has resulted in huge problems. I had also a chance to listen to, I think, Rajiv Khosla, who did Bhumi project in Karnataka, and the kind of path-breaking work done.
Rajiv Chawla.
Rajiv Chawla, I'm sorry, yeah. Rajiv Chawla, the fantastic work he had done. So there are a lot of examples, but it seems to me that we need champions everywhere. But anyway, I think there'll be other occasions to make comments. Let me introduce the discussant today in this session. We have Sanjay Kumar. Is Sanjay there?
Yes, sir. Good evening. Hi, I'm here.
Yeah, hi, Sanjay. I'm very impressed by your track record. 10 years in Indian Air Force. At the age of 17, joined IAS, did a master's, did research in Rwanda and Argentina. I am most impressed, Sanjay, and he's now Secretary Revenue, Government of Goa. So great to have you, Sanjay, as the discussant.
Thank you.
And the first paper is on characterizing land and property related litigation at the Delhi High Court. Is being has been done by Devendra Damle and Karan Gulati, both part of NIPFP. I am told that Mr. Damle is away on tour or traveling and not able to attend the Zoom call. So we have the pleasure of Mr. Karan Gulati making this presentation. Karan is he is part of NIPFP, as you said. He's a trained lawyer and research fellow, and his research interests include judicial administration and property rights. He also has a combined BA LLB degree from Symbiosis Law School. He has also received certification in international law from Leiden, that is the university, The Hague. So, and completed a course on America's unwritten constitution from Yale University. I will also introduce other participants from the second part of the session when we come to it. May I now request Karan to make his presentation.
Thank you, sir, for that wonderful introduction. I'd also like to thank all the illustrious speakers that have spoken before me, and I'm honored to be here at the conference organized by NCAER. I would, of course, be remiss to not thank Media Network for all the support that they've given us for the research that we've conducted. I'll just try to share my screen. I hope this is visible.
Yes, it is. If you can just, yeah.
Yeah. Devendra and I have done some work on characterizing disputes at the Delhi High Court. As an overview of how this project started, it had twofold purposes. One was to study general litigation at the High Court, and the second was to, of course, look more elaborately into land record cases. Our findings, and I'll get to them in detail, are contrary to, or rather, are not in line with popular opinion of land and property related litigation being a burden on courts. We also have some interesting findings on how heavy land records are a caseload at courts in India. As has been discussed over the course of the past hour or hour and a half, land and property disputes are thought to form a significant proportion of disputes in the Indian courts. Popular conjectures of this are that poor land records lend themselves to disputes between parties, as well as the wide array of laws that govern land administration in India due to the subject being given to states instead of the center, which has created the complexity of operation between laws. We feel, however, that this premise has not been sufficiently established with evidence. And we wanted to see what we can do about this, especially at the Delhi High Court. We've created a novel data set of case level data at the court and tried to test some of these conjectures to the best of our abilities. We answered questions, or at least tried to do so, for the volume of such disputes at the court, the duration that they take, what type of disputes are these? Land records are, of course, a subpart of all land and property disputes at the court. And perhaps just as importantly, who's coming to the court? Why did we choose the Delhi High Court? Well, a lot of work has been done about the workload of the Supreme Court of India, and this is important, and we've learned a lot from this work that has been done. However, we feel that this doesn't portray the entire picture of disputes in India. Our work suffers from some of the same limitations. However, we hope that it improves on some of them as well. This is because the Supreme Court of India is primarily an appellate court, with some work such as Robinson's work in 2013, of course, and our personal experience showing that special leave petitions, which is an appellate procedure to approach the Supreme Court, constitutes the majority of its workload. That means that most original cases aren't, or rather the Supreme Court's workload is not primarily original. The court is also national, and therefore it's difficult to understand the type of disputes that originate across states. The Delhi High Court, one could argue, is also an appellate forum. But aside from being an appellate forum, it also has what is known as original jurisdiction. It is one of only 5 high courts in India which has this jurisdiction. This means that people of claims above a certain monetary amount, which is rupees 2 crore, can come directly to the High Court. This bypasses some of the limitations of it being an appellate court. It also bypasses, we hope, some of the limitations of studying national level data, because, and we try to study state level data because land administration and land records are likely to differ across states. How did we identify cases at the Delhi High Court? It's perhaps the most important question one could think of. The way we did this was creating a 2-level filter process. First, we excluded all matters which we prima facie knew would not be of interest. This included criminal cases or tax cases. These are the substantive cases that we've excluded. We also excluded procedural matters. These are caveat cases, and as an example, what this says is, I go to court, I say X person is going to file a case against me, or at least I think she's going to do so. So I tell the court, please tell me whenever this happens. That's what a caveat case is. And it's easy to understand why these will not be by themselves land and property related disputes. Next, we created a multi-stage pattern recognition protocol. And this lended itself to better identifying property disputes within the case types that we had selected. The first step, not that this is stepwise, was a comprehensive list of statutes and policies that indicated that a dispute related to land and property. As an example, we took the Delhi Rent Control Act as well as the RERA of 2016. These are only examples, and we tried to create an exhaustive list of these statutes. We also included a list of negative terms and phrases. Phrases such as the Competition Commission, copyright, labor courts, etc. When they appear in a judgment, we decided that these disputes are not related to land and property. Again, these are examples and are a part of a hopefully exhaustive list. And third, of course, we had a list of positive terms and phrases, which we believe pointed toward land and property related disputes. How successful were we in this operation? We drew a sample of 400 cases, which we checked manually. This entailed reading all the cases and classifying them whether or not they were land and property related disputes. We found 9 erroneous classifications, which was an error rate of 2.25%. All of these, interestingly, were false positives, which means that we are probably overestimating the caseload related to land and property disputes. As I'll come to in a second, we also have another sample of 600 cases, which though weren't read for this purpose of checking our error rate, were separately read manually for another purpose. And there too, we saw just as small as an error rate. There we saw, if I remember correctly, 11 out of 600 cases being marked erroneously. Again, all false positives. What did we find? We looked at close to 91,000 judgments at the Delhi High Court. One caveat here is that we looked at judgments and not orders. To those not as aware about the Delhi High Court's operation or other courts in India, judgments differ from order in the sense that these are decisions on merit of the case and are not simple dismissals, such as saying that the party hasn't appeared or that you don't have a case. This is where the court has heard the entire case through the course of its tenure and then given the judgment on merit. Of these, we found 41,648 case types of interest. Again, this is where we've excluded criminal and tax matters. As it so happened, some of them, though were said to be available on the Delhi High Court's website, we were unable to download the judgments for the same, which restricted us to close to 40,000 odd judgments. Pattern matching protocol then yielded 14,495 land and property related disputes at the Delhi High Court. This is 36% of the 40-odd thousand cases that we were able to download. What was the information we were able to secure from this? We secured the case type. We secured the year of filing, as well as the date of the judgment. And we also secured the name of the parties that appeared before the court. The last head was then segregated into several categories. This included union, state, companies, private individuals, organizations, etc. As part of a separate study that we are doing at NIPFP, we've checked around 2 lakh cases for this set of categorization. And though this categorization is not at the part of the Delhi High Court and is again what we've automated, in that separate study, we found an error rate of close to 1%. And that's why we believe that our categorization of these parties into union, state, etc. should be optimal enough. What did we find? There has been a decline in property disputes in our data since 2015. Now, it's important to understand that this may not be indicative of disputes at the High Court. And this is because if a case was initiated in 2019, it would only be in our data set if it was also decided by the time we stopped looking at the data, which was September of this year. As you all know, cases in India take some time to be decided. And that's why it's obvious why more recently initiated cases will not be heavily represented in our data set. However, we also calculated the proportion of disputes. As I've mentioned earlier, 36% of cases are land and property disputes. And a year-wise segmentation of them yields that there has been a decline in cases from 2017 till 2019, with a slight uptick in 2014. The reason that plot isn't represented here is simply because we are exploring that in more detail. And we want to have better reasons before we get into it. However, the conjecture we have right now is that the uptick in 2014 might be due to the enactment of the Land Acquisition Act on 1st of January of that year. What is the type of cases that are coming to the court? Writ petitions, which is a case at the court alleging the violation of a constitutional right, is the foremost type of case before the court. This constitutes close to 36%. Original cases, as I mentioned, are cases where the monetary claim is above rupees 2 crore and where parties have come directly to the court. This is followed by appeals and then rent control applications, so on and so forth. Who are the parties that are coming to court? Now, while it is thought that the government is the largest litigant in India, our evidence does not suggest this. This may be, of course, due to the fact that we're looking at property disputes. And one reason that the government is a large party is due to criminal cases, which we avoided in our data set. However, interestingly, what we see is that the state is the second largest respondent in our data set. What this means is that often private parties as well as companies are suing state governments in land and property related litigation. Similarly, the municipal parties are not as high a respondent count in our data set, representing only 658 odd cases of respondent. It's important to note that for the larger set of 40,000 judgments, which are not all land and property disputes, we have only 12,000 of them. That means often, if the municipal party is a respondent, it is related to a land and property dispute. We also looked at the nature of the dispute. Now, unfortunately, till now, we haven't been able to build better mechanisms instead of manually checking them to categorize disputes into what the dispute is about. And this is where we looked at a sample of 600 cases. This is separate from the 400 odd cases that I discussed earlier. And we then classified them into 7 categories. These are eviction cases, land acquisition, family, contractual, allotment-related cases, mortgage, and others. It's important to understand that not all of these are mutually exclusive. For example, an eviction matter might also include a mortgage, and that is why the eviction has come into play. Eviction matters, interestingly, or rather unsurprisingly, to be honest, are the largest category of disputes in our sample of 600 cases. They constituted 213 of the 600 cases that we've looked at. This is followed by land acquisition proceedings. Now, it's important to see that land acquisition cases constitute about 1/4 of the disputes. But if I were to go back to how many land acquisition appeals, which is a separate case type at the Delhi High Court, we will see that there are only 2% or so were land acquisition appeals. Now, why is this happening? We believe that the reason for this is that parties are filing writ petitions when they have a land acquisition dispute. Writ petitions, as some of us might know, are perhaps what the court thinks of as the most important dispute before it. And our conversations with practicing advocates, as well as our own experience at courts, suggests that parties also believe the same. And that's why they prefer to file writ petitions if they can, instead of going in separate heads of cases, because they believe the court is likely to, for example, list it earlier, after one hearing, list it again sooner instead of later, and give other priorities wherever possible. How many of these were land record cases? We are currently in the process of automating and finding out how many land record cases are included within our 14,500 land and property disputes. And our preliminary findings are based on the sample of the 600 cases that we've examined manually. Land record cases are often mutation disputes. And interestingly, we found that only 30 disputes of the 600 cases that we've looked at related to land records. This is only 5% of our sample. Importantly, our sample is is a subset of the larger set of 14,500 cases, which means it's again a subset of the total cases before the court. If we were to look at, hopefully, if this lends itself to proportionally scaling, it would mean that only 2 to 3% of all disputes at the Delhi High Court relate to land records. This is unlike previous findings, such as that at Daksh. One of the reasons for this might be that Delhi is an urban state, and therefore land record disputes are few and far between as compared to Daksh's study of Daksh's pan-India study. I've tried to keep this presentation brief. Some of the findings that we've come at, such as the duration of disputes, has not been included in this presentation simply because they're not as interesting as or not as interesting as other things that we've looked at. But importantly, some findings that are of note is that 36% of all civil disputes at the Delhi High Court, we believe, are land and property disputes. This is much less than the commonly understood number of 66% or 2/3 of all disputes. Again, one reason for this could be that we've looked at all parties coming to the court. So this could be a dispute between a CPSC and a private person. It could be versus a company, so on and so forth. And the earlier number of 66% is based on a litigant perception survey, which only examined individuals. And therefore, our number is much smaller than that. Similarly, again, we've only looked at Delhi as opposed to a pan-India study. And in improving the study, we aim to look at other courts. And it might be that this number increases if we go outside Delhi. Writ petitions constitute the largest case type. A conjecture for this is one that, well, one is a non-conjecture statement that writ petitions just might be what the largest type of dispute is. But the other is that parties believe that courts prioritize these petitions and therefore seek to file their cases within them. Eviction disputes, on the other, similarly represent the largest proportion of cases. And challenges to land acquisitions are the second highest. Again, we believe these are filed as writ petitions instead of regular civil suits or land acquisition appeals. Most disputes involving immobile property are between private individuals. These are private versus private disputes, or often private versus company disputes. And lastly, an interesting finding we believe is that land records are not responsible for as big a proportion as is commonly believed. However, it is possible that when we look at the entire sample of 14,500 cases, this number slightly goes up, as well as it goes up when we look at other states in India. This work is part of a larger study. The current presentation is based on building a library of all land and property disputes, and it's the first step in a more detailed analysis of disputes. At the Delhi High Court, we next intend to focusing, again, as I've said, automating and relying on the entire subset of land and property disputes to find land record cases. We also want to look at salient land and property cases and how courts decide them. This is of particular importance to see the court's attitude towards certain proceedings. And the next step is, of course, to look at subcategories of eviction and land acquisition disputes. A manual reading, for example, suggests that land acquisition disputes primarily arise because the state initiates an acquisition proceeding, but fails to take actual possession. And that's why after the lapse under the Act of 2013, as well as the previous erstwhile Act, parties have the right to come and say that you haven't taken possession of my property, so please do away with the proceedings. Future work will also focus on other high courts in India. This is especially to understand state-wise variation, which is again of particular importance to land record cases. Thank you for NCR team for having me at this seminar.
Okay, thank you, Karan, for a very interesting and informative presentation. It's a very impressive study, and there are already a lot of interest and questions coming in. Let's look at the second one before we get to discussion and question answer. It's on international lessons for improving cadastre-based land records. It's written by 5 persons. Kajal, Gupta is a research associate at NCAER and was a part of NCR Land Policy Initiative as planning executive. Also, Anika Kapoor, she is the project manager for Land Policy Initiative at NCAER. And then we have Aswani, Mr. Aswani Munnangi. He's a consultant and part of, again, the Land Policy Initiative at NCAER. Deepak Sanan, he's already been introduced. And the last is Mr. Somnath Sen, who advises multilateral and bilateral development agencies and international NGOs and governments in India and elsewhere. So may I request Kajal, I think, is making a presentation. Kajal?
Yes, sir. Yes. So thank you for this introduction and introducing my co-authors. It was really interesting to listen to the previous study and very interesting findings. And it was interesting to listen to the previous speakers. Thank you. So I am sharing my screen. So I hope the screen is visible.
Yes, it is.
Okay. So let me begin. So we wanted to study the cadastral land administration in India and then learn from the international experiences. So building on a series of schemes since 1980s, Digital India Land Record Modernization Program was launched in 2016, which is the latest program in India, which aims to improve the land administration by having an up-to-date textual as well as spatial records. But when we see the work done with spatial records as compared to the textual records, there is a significant gap. Even NLSI 2020, National NCAER's Land Recording Services Index 2020 found that as compared to the digitization of RORs, digitization of cadastral maps is much lower and in very smaller number of states. Only 19 states and UTs out of 37 have a dedicated portal or some kind of digital platform where spatial records, digital spatial records are available. This shows that a significant amount of work needs to be done in the area of spatial domain of land records. So for that, we had a review of the literatures to understand the relative poor performance in digitization of spatial records, the reasons behind it. So there were three major constraints that we found. One was the variation with the legacy records. So there were problems in data mismatch, variations in calculations of area when when you survey with new techniques, and they had only resulted in disputes and legal challenges. The second constraint that we found was the difficulty in continuous update of spatial records. So there are two aspects to it: how to initially update your existing records, and how to update the records once they are digitized. The third constraint that we had was the lack of data for the land where customary laws apply. So there is no data, whether textual or spatial, for these areas. So there are gaps in the complications to understand the law under which these land are governed. Some customs are like shifting cultivation and various complication matters otherwise. So this paper carried out a review of international experiences to understand if there can be any lessons for the Indian states. So the countries studied for this purpose were included Denmark, UK, Malaysia, Indonesia, Rwanda, Australia, and Lithuania. These are among the countries which have recently been observed have taken initiatives in improving the land records, especially in terms of cadastral maps. So first country, that was variation in legacy records. So problem in legacy records arise when using a new survey technique, the area differs. So it is mostly because when we are trying to georeference these isolated parcels, the area changes. And they were never made with that kind of intention that they will be spatially located on a projected coordinate system that we currently use. The second was when we try to actually georeference these, their boundaries get distorted and thus the area varies. And sometimes the location also changes. As there are legacy records, a de novo survey, completely new survey cannot be the solution, as it will only lead to disputes and litigations. So
Kajal,
yes,
sorry,
Karan.
your screen is not updating. We can only see the heading,
Oh,
constraint one, variation with legacy records.
okay.
Maybe you need, yeah, that's great. Thank you.
Right. So, right. So, so in the initial phase, there was 100% assistance for a resurvey and survey in India from the central government. But what each state found was that it was very difficult to conduct new surveys, and some states tried it on pilot level, but really could not find success. An NCR study in 2018 actually first did a study for Maharashtra and Himachal and found out that the area was varying a lot to an extent. So the potential reasons for that were found to be like the owners lacked knowledge about true extent of their land area. They most often did not even find the importance to measure and demarcate the plots. Some plots were bifurcated but not mapped, but only the area reflected in their textual records. So it was really difficult to map these area in your spatial records. Even a pilot in the Mulshi, Maharashtra showed various deflections from the area. These problems were only solved informally among the people of the village themselves in group meeting. In Haryana, also a detailed exercise was conducted, using satellite surveys, but they could not use that data because that data was not legally backed up of how to use those boundaries in terms of the area that it was reflecting, because there was a lot of variation in those areas. So when we saw the international cases, the lessons that we learned was that you need to have a purpose of your survey technique with the map that you're generating. So they use the concept of fixed boundary and general boundaries. So general boundaries are nothing but your cadastral map mapped over a Google satellite imagery, whether with a new technique or vectorizing the original map and overlaid over satellite imagery. Whereas fixed boundaries were plot level detailed, surveyed, resurveyed by the local surveyor and updated whenever a mutation or registration has to take place. But it must be noted that they had licensed surveyors to do those processes, and they had a system in place to actually resurvey those plots on a regular basis. And they actually gave the importance in Denmark and Malaysia, especially, that they gave importance that the spatial record need to be updated when any mutation or registration or any transaction on the land has to take place. And that is how we also can update the map on a regular basis with which can match the legacy record. So you need to trace back to the transactions that has happened earlier. In Rwanda, the countries like Rwanda, Lithuania also realize these importance and follow the same path of fixed boundary and general boundary. So what they use is that the traditional surveys that at plot level were conducted in India, maybe called as tippans here. So they have given those land records at a plot level a very legal value, so that the boundaries that you generate from an overall cadastral map is gives you a lot of inaccuracies. But a survey conducted at a plot level with various new techniques, even participatory surveys as involved in Colombia, they did a participatory survey where the people themselves mapped their boundaries using a device. So they were happy with the area that were coming in. They had the neighbors looking, they had a group meetings to mark those, like there is no neighboring plot overcoming their area. And these surveys were actually used to match the legacy record, to have the measure the difference between the legacy record and new records as well. This exercise in Colombia gave results for 3 villages, updated records within 1 month of time. So this is can be done. Second, second problem that we face in India is the continuous update. So the two problems were, the first is updating of legacy record, which can be attempted and used with the last discussion that we had in the previous slide. The second is a platform in a working institutional system to keep updating the records once they are in the digital environment for easy management. Currently, there's a lack in the whole detailing out of the institutional procedure in who do the changes in the digital environment, how is it happening, who are the officials who are concerned with it, when are the changes taking place in the digital environment. These are certain kind of things which are not recorded, and thus the it is not giving the value how and when the record was existing and what date of that record is available on the net. The NLRSI 2020 actually pointed out that we do have a digital enabling environment. Data is available, entries are also happening, but they have a mismatch with the textual data in terms of area, especially. And thus, efforts are really required to integrate these processes in international cases. In all the countries that we studied, and especially in Australia, they had enabling environment which coordinated among departments. Uh, uh, which had an enabling environment which coordinate among the department with digital processes in place for registration, for mutation, and the data that can be changed on a digital platform by the surveyor and by an expert who can change it on a digital platform. So you need these kind of human resources to undertake these tasks, to continuously update your records once digitized. Australia especially uses a date stamp method and gives an official's ID on their record on the bottom, that this official on this date has changed this record, and this was the day when this record was changed. So these mechanisms are there on paper in India, like the field measurement books, but these can become effective only if these are properly maintained and make benefit of the digital environment that we currently have. So you need the processes in place to be able to coordinate with the other department, registration, mutation, the sub-registrar's office. These needs to be coordinated on a digital platform to actually be benefited from the data exchange and updates in a digital platform. And especially you need a detailed out procedures, who do what and how are these done. These needs to be legally backed in acts and rules to define the responsibilities and who undertakes what. It may also be noted, which is a subdue point, but when we see that the projection system needs to be coordinated, and that is why there are a lot of overlapping boundaries when villages are mapped over each other or state boundaries are overlapping, and thus we do not have a comprehensive database of villages with their maps. So the cadastral maps in Malaysia actually faced this problem, and they had to redo the whole exercise again on the common projection system, which is a very technical part, but India too needs to devise a plan to anticipate this issue. The third major issue was lack of records where customary laws apply, especially when we see villages and communities in many states of India, especially in the parts of Northeast and Central India, govern their land under various customary laws, and no state, actually the state has not we do not have any state level documentation of what village, what area, what extent is governed under which customary laws. So there are n number of customary laws in place, and there are huge chunk of land which is governed under these land, but we do not have any record for those. This leads to data gaps and conflicts between communities and government agencies. When we see particularly some practices like in Manipur, the Kuki community practices, they have like redistribution of land with the village heads. It's the village heads' responsibility to socially to equitably distribute this land among the community members. It's his social responsibility, but then there are various problems like village head occupies more land, and these are not equitably distributed. But we do not have any record of where what all land is governed under such kind of laws. So these practices, these but there have been few researches on those, but a very sporadic efforts has been taken place with no proper database with the state government. So the problem finally with customary laws is how to map these lands, how to classify these customary laws, how do we list them out, what attributes are to be taken for data management, how to survey these areas, because it's a clean slate, no data is available. It has been realized in few countries that we've taken up, especially Malaysia, Indonesia, which have a lot of indigenous land, that it is not at all an easy task. It needs intense participatory survey, plus you need willingness from the community to actually participate in the surveys. Indonesia actually faced these issue because they initially mapped all the land with the all the land on satellite, but they saw many protests from the forest dwellers, from the indigenous people, and various communities which were practicing customary laws. So the second example is from Malaysia. Actually, Malaysia has been doing these surveys and they have been successful because they have institutionally given them a title called as qualified titles, which are a kind of temporary titles given to communities, given to the people, and these are mapped whether these rights are sellable or not, whether these rights are changeable or not, how does the law apply over that land. But Malaysia has realized it's a time taking process, but they are positive that once this exercise is done, they will have a huge database actually for the whole land of their country, how every land is governed, who owns what, and what are the community rights over that land. So India can also plan a similar exercise in in the states, and we need exercise planned specifically for Indian context. Maybe an approach to prepare a template, do test and to start survey in a phased manner. It's just an initiative to actually document these land. But before that, it is a very important step that the strategy has to be faced, and prior to that, how will that data be used and managed and updated, and the responsibility of each official person has to be detailed, how to include the local level information, how to have the local level leadership to be in place to benefit from it. All these things are to be intensely documented. So in conclusion, India is on the right path in terms of digitizing the spatial record especially, but are having few difficulties. So a concept of general boundary and fixed boundary can be adapted to actually identify which technique should be used for both these purposes. And this can actually fasten the digitization and record maintenance purposes. Currently, Indian states have the field measurement book, but there need to be a system to continuously update with everyday vision that occurs. They need to be given the legal importance to spatial records. And we need to have proper number of surveyors, especially awareness among the owners to actually mark their extent, to have their extent of area marked on a map, so that so they know what their area is, where their area is, and how does the boundaries demarcated. Indian states need to work immensely on planning the exercise to undertake surveys for the land records and governed under customary laws. And finally, benefit from the digital environment that we currently have. The only thing that is required is extensive training of the individuals to be given importance, and the institutional procedures are to be detailed out in the in legal acts and policies that govern the land in that particular state. So thank you very much. Uh, I hope this was interesting to listen to, and thank you.
Thank you, Kajal. That was a very interesting and extremely informative presentation and study. Must compliment you and your colleagues who have done this. Let me give some brief comments before I invite Sanjay and others. My experience has been that the land dispute and the absence of credible titling documents and not updating of land records gives rise to litigation everywhere. Of course, it's good to see study in the Delhi High Court, but also, as has been pointed out by Karan, Delhi may not be a great representative case because it has basically urban areas where the issues of land disputes are not that many. If you go to a typical state or a district in UP, Bihar, or some other place, I mean, you will find very enlightening information at the same time. And it's good to know that you are going to continue the work. As a matter of fact, the cases are pending in high courts, district courts, sub-district courts, and also a large number of cases are always with the revenue authorities. As a matter of fact, the number there is extremely large. I also recall that so many litigations are filed because of land disputes under the Criminal Procedure Code. You know, people try to take resort to section 144, 145, 146 because of land disputes. And also because the court processes are slow and disposal is poor and very inadequate in everywhere, whether revenue officers or civil courts, it gives an incentive to people who have dubious claims over a title to file these cases and then create problem for everyone else. So unless and until we really focus on updating of records, because that is really the key. The point has been made, regular updating of record through surveys are required. And also this point has been made that we must have a digital environment in which the various offices in government are talking to each other. You know, like the survey, the land record of rights are maintained in one place, cadastral and survey maps are maintained in another. And then you have got registry offices registering documents of transfer of title. And then you have mutation happening in some other office, and the people, they rarely talk to each other. Very commendable effort has been made. At least I know from my work in DPIIT that Bombay town is definitely among the better maintained land records, but there they have property cards and they have got much better communication. But I think unless and until these offices are talking to each other in a real-time manner, and all the information is also available for public to see, it's very difficult to find any credibility with the kind of title that people claim. So I think this is great work that has been done. Let me invite first Sanjay to give his comments. He is directly looking after land administration as Secretary Revenue in Goa. Sanjay.
Sir, thank you, and thank you to the team who have given me this opportunity to be able to comment on these wonderful papers. And thanks for Karan and Kajal for presenting your papers. On Karan, I would like to address you that you saw the drop of cases after 2015. I think you may have missed it, but the reason was very simple. Delhi High Court Act was amended in 2015, and the monetary limit of financial cases was increased from 20 lakh to 2 crore in Delhi High Court, and cases were shifted from Delhi High Court to lower judiciary. So after this amendment, about 12,000 cases were supposed to be shifted. So you can take it from me, and you can just Google it, and you will find that this amendment was done. So that's why you had to do this. You can do analysis post 2015 and pre 2015 for better understanding. Because the cases will be now, they will be, you can quantify them as per the value also. So that's one thing. In your paper also, I've seen that you could not find the reason, but that was the reason. Second is your finding are similar to what is an international experience, and international studies have shown similar things. And though it is not a common wisdom, but still I'll put it this way, that actually land record may not contribute to a lot of cases, but lack of cases doesn't mean that better land administration is preventing land disputes, because the number of land disputes are less because people do their due diligence rather than we land administration preventing happening of such cases, because otherwise it happens. Delhi High Court has another very peculiar case, that in Delhi, the land administration is missing in most of the urban district. It is there in the rural districts. So revenue courts are only in few districts. So the case and appeal doesn't go. So hopefully when you move to different states, you will find some different findings. But as I know, I was Deputy Commissioner, New Delhi district. So I was handling all these revenue villages, Samal Khan, this Delhi airport side. So I know that in urban area, there is complete lack of any land administration. So far so that there is no law which governs a recording the property or their interest after freehold, even for DDA properties, after they become freehold. So that's why that doesn't happen. Then the another case is large scale land acquisition cases which were done by the DDA. Hundreds of villages were simply acquired, and thereafter most of them were not taken up for development. And these cases are now, you can see in these land acquisition cases which you see. So you can analyze that point also. Third is unauthorized colonies. In unauthorized colonies, you will see there is efficient market, very active participation, properties, and people are selling. I know, I have first-hand information. I know people, and even a high value properties are being sold and purchased. Very efficient and efficient property transactions are happening, but it is not driven by credit. Everything is happening without going to bank. So that's the problem. So you have to account for it somehow in your studies, that how the unauthorized disputes from unauthorized colonies may be coming up in the Delhi High Court. Also, when you have mentioned about government being party, there I'll say that the government is many times is only pro forma party, even in private disputes. So just see whether it is a pro forma party or it is really a party. In eviction cases, in land acquisition cases, government would be the active party. Otherwise, in most of the other cases, it will be pro forma party. So when you do the data analysis, you can see that part. And so that's all from my side on your study. I'll simply say that I'll add to what Abhishek has just said, that Delhi High Court is not representational, but world over studies have shown that civil disputes constitute about a similar percentage of cases, and most of the cases is between parties, and especially inheritance, succession, and these kind of cases, rather than actually related with the land record, because people, even in absence of land record, they do due diligence, and that actually prevents and maintains the active property market rather than actually the absence or presence of land records. Sir, may I continue with, or?
No, please continue. There's no problem. We have time.
I may comment on the Kajal's paper. Kajal, I'll just say that you have to, I'll say the topic is too broad. You have mentioned too many things. So I think I found that topic was too broad, especially when in the first slide you have mentioned regarding digitization of cadastral record versus cadastral map. I would like to understand how the cadastral map is more than 70%, and cadastral map and record, how, and ROR, cadastral map, and cadastral record, you have segregated in 3 categories. So I would like to clearly understand how do you define cadastre. That is an important terminology. It started from the continental Europe. So I would like
Have we
It
lost?
appears we may have a weak connection, or he may be reconnecting. Um, Sanjay, if you can hear us, perhaps it's best that you reconnect on a better connection. We can't have the Revenue Secretary of Goa on a weak connection. Uh, we may not be able to get him back quickly. Ramesh, maybe we should open it up to Q&A and maybe perhaps even a comment from Karan on the important point about the change in the value, the threshold value of cases. That's a fairly important observation, I thought.
Yeah.
But over to you, Ramesh.
Please, Karan, let's have your comments.
Sure. Though we've lost him, I'd like to thank Sir for his valuable comments. It's well taken that in 2015, the Commercial Courts Act was passed by Parliament. This slightly changed the jurisdiction of the Delhi High Court. And it's correct. So there were two primary changes to my understanding. These were, one was changing the monetary value of original cases, which went, as Sir said, from 20 lakh to 2 crore. And the second was the establishment of what are known as commercial courts. And that's why separate commercial case types were added. So you would have originally arbitration petitions. And after 2015, you would have arbitration petitions as one case type and arbitration petition commercial as another. And though we'll make sure to take note of this in our paper, it is perhaps not as drastic an effect on our data. Again, it's still well noted. And the reason for this is we've looked at case types, and the change in monetary jurisdiction only affected what is the original jurisdiction of the High Court. And as you've seen, writ petitions constitute more than 54% of the cases in our data set. And unless something in practice was different at the Delhi High Court, that caseload should not have differed in 2015, or rather 2014 and 16. But that's right, and we'll make a note of original suits, the difference in original suits in 2014 and 16, and continuing in the paper. Just to address the other comment, and we're great. It's good to know that our findings align with your experiences. The other comment I'd like to address was regarding pro forma parties, and that the state might not be a necessary party and might be a pro forma party before the court. Our methodology only looks at parties which were the first party in a litigant type. So for example, if the respondent is Union of India and others, we're unable to look at the composition of those others. This means whenever we've recorded state, center, municipal, or other government, or CPSEs or SPSEs, they were always the first respondent or the first petitioner. Now, there is nothing in law saying that the first petitioner should be, or the first respondent should be the main petitioner or respondent, but at least my experience working in court shows that this is always the case due to obvious reasons. So we are probably by default accounting on removing some of the pro forma parties, because we're not looking at others and others in respondents and petitioners. But we are happy to relook and see if we can devise a better methodology to exclude these. Thank you.
Kajal, do you want to come in here?
Okay.
Ramesh, Sanjay is back, and maybe we should just let him complete his comments and then request.
Yeah, sure. Sanjay, do you want
Sorry,
to?
sir, it got disconnected, and thanks, Karan, for clarifying those points. I'll be very happy if I can be of much value. Kajal, just you initially you began with very good point that you differentiated between modernization of textual record and spatial record, because a common approach I have seen as not yielded good result, and the solution of these both the problems is different, and you should segregate it. We have successfully digitized our textual records, but we have not been able to successfully digitize our spatial record. You have mentioned the reasons correctly, but I didn't find when you mentioned that they solve the problem with journal, and you were not very specific that what solution did they use. You did not clarify whether they use a general boundary or fixed boundary, because as I know, all country face this problem which India is facing, and we didn't look outward that how solved it.
I think,
especially in the case of, when you mentioned the case of Rwanda, is number one in the quality of land administration. Okay. Oh.
Yes, you are. Sanjay. Yes, you are audible.
Sanjay, are you there? No. I think there's a quite
Yeah,
a
we move on. Let's move on. Yes.
connective issue. Yeah. Kajal?
Yeah, I audible, sir? Now?
Yeah, okay. Yeah, please come. Yeah, continue. Yeah.
So, sorry, sir. I think it's interrupting at the wrong time. Otherwise, I was able to hear it clearly. On Rwanda,
I think till we have a stable connection with Sanjay, I think let's Kajal. I think you can comment.
Yes. So I understood two questions that I need to define. One was the meaning of cadastre actually. So cadastre has two components. One is a cadastral map, that is a village level map, and the another is a cadastral plan, which is a plan of a plot level record. So that plot level record, when you subdivide, it becomes subdivisions of that plot. So in Tamil Nadu, in Andhra, and Telangana, we have these maps totally digitized on a platform where subdivisions are also marked with your plot lengths, but they do not have the cadastral map in public domain. Whereas other states like Maharashtra, Uttar Pradesh, and even Madhya Pradesh and Chhattisgarh, they have the cadastral map digitized, where the plot lengths are measured from the overall cadastral maps. So this is so that is the problem, that you need to have the overall cadastral map when you digitize it from a paper which was made on a certain scale of the paper size. So when you digitize, you are bound to have an inaccuracy in plot level data when you measure it from top to down. But when you measure the correct boundary from a plot level data, and then you make a concept of general boundary at a major like a village level, that is our concept of general boundaries. So you have them for address location, for parcel identification. You make a simple line demarcating if there is any subdivision that takes place after the digitization, from obviously from a digital environment in a shapefile for GIS based shapefile, whatever platform they are using. And you have a isolated parcel surveyed using different techniques. In Lithuania, I was speaking about, they've used GNSS, which actually provides a resolution of even approximately 30 to 50 centimeters. So when in Colombia, I would specifically say that they've asked the people themselves to move around their boundary of their plot, and that area is calculated, which is re-verified from the collective efforts of the neighbors in a group meeting. Once you make a overall digitized update the digitized records of a particular village. But overall village level, they have common maps of villages with every subdivision marked with a line, but those measurements at a level is not used for your legal records. These are only for parcel identification. So that is the concept that they've used in Colombia, Lithuania, Rwanda, and even in, England, Denmark. And I would like if Deepak, Sanan, Aswani, Munnangi, Somnath Sen, or Anika Kapoor would like to add on to this question.
No, I think the key point, Kajal, which Sanjay was raising was that you started with a very good division between the concept of textual and spatial records, and brought up the idea that why textual records digitization is obviously easier and has gone forward. And your focus was on the constraints which are affecting the spatial records from getting modernized and becoming available in a modernized format. What is preventing that from happening was what you were trying to address. And I think if you maintain that focus, that would be very useful going forward as you revise your paper and improve it. That point is that why is a modern, up-to-date, say, record of in India of the spatial dimensions being slow in arising, and continues to have problems, and how do we deal with that? Yeah, I think his point was very valid in addressing that issue.
Okay, any comment from other experts, panelists?
Ramesh, there are a number of questions on the Q&A box. Some are directed at Karan and Devendra. I guess one question from Kala Sridhar from ISEC. From my understanding of your methodology, Karan, it was really an arm's length approach. You did not actually have any contact with the registrar or any other element of the Delhi High Court. You really went to the websites, you scraped the data, you used a machine learning tool to do pattern recognition of syntax and terms and things like that. And so this was a complete remote exercise, which of course is possible for any digitized high court. So maybe you could address this methodological question.
Sure. Thank you. So yeah, I apologize if I didn't get into details of where we got our data. We looked at the Delhi High Court's website, which experience shows is one of the better digitized High Court websites in India, perhaps barring the Bombay High Court. And what we did was there are two data sets at the Delhi High Court's website. One is an orders data set and one is a judgments data set. We looked at the judgments data set. As I slightly touched upon in the presentation, the judgments data set is where a dispute went through its tenure at the High Court. This could go through multiple judges. Unfortunately, in Indian courts, that's often the case. But notwithstanding that, several hearings took place, and then a judge gave her decision on the matter on merit. The orders dataset, on the other hand, is often one-word orders such as dismissed or disposed. This could be because parties didn't come before the court or their case is prima facie without any merit. And therefore, getting into them doesn't really help us in understanding how courts are dealing with land and property disputes. That's why we've looked at the judgments dataset. Also, of course, if these were one-word orders, we couldn't have possibly analyzed their text because there wouldn't have been any. As for going further into this research, as much as we want to look at other high courts, as it so happens, often urban high courts are one which are better digitized. Fortunately, in 2016, under the Chief Justiceship of Justice Chandrachud at the Allahabad High Court, they did a good job at digitization of the court records. And perhaps Uttar Pradesh could be a good subsequent case study. We've also looked at the Calcutta High Court, which again is probably not an agricultural state, but lends itself to giving us data perhaps much more easily than other courts. This is also the problem why we are unable to look at district level or revenue court level data. And as much as we'd like to do that, a different NIPFP study shows that e-courts data, which is where you would get district level court data, is not a useful tool for detailed research. And that's why if we were to get into that data, we would probably have to partner with a revenue court or a district court and get their manual records instead of their digitized records. Hopefully that happens someday. But at present, we are restricting ourselves for that reason to high courts. But we like to go into agricultural state high courts, possibly. One case would again be the Uttar Pradesh High Court or the Allahabad High Court.
Did you have a chance to look at this National Judicial Data Grid? Is it of any help?
Yes, sir. So that's the thing. The National Judicial Data Grid and the e-courts platform are effectively one and the same. And though the Supreme Court committee is doing good work in improving it, currently another study at our office shows that there are several missing fields or incorrectly entered fields. And that's why research upon that data would probably suffer from several errors. And that's why we don't want to get into it.
Okay. Sanjay, you are back.
Yes, thank you, sir. Sorry, but let me continue from here. I just wanted to add that
I think we are not going to be able to hear Sanjay.
Yeah, maybe you can just try the audio, and maybe that connectivity is just enough for audio, maybe. Yeah, we are not having full benefit of his knowledge right now.
That is true.
Yeah. So anybody else would like to come in here? There are not too many questions. I mean, most of the questions we answered related to this availability. So
Ramesh, I have another question for this very fascinating work that Karan and Devendra are doing. And the question relates to, in fact, to orders. They've looked at judgments. It is possible that even orders take a fairly long period of time with repeated adjournments, litigants aren't there, there's no time for the court, passovers, all the usual fragilities of our Indian court system and our legal profession, to be fair. Where a typical counsel, or certainly a senior, will have 25 cases on one morning or one day, and it's almost impossible for him to cater or her to cater to all of those. So in those situations, very often property disputes, which will end up in a dismissal, will also place a huge load on the court system. And you could have an order that is a one-word order, but it's taken 6 years or 3 years or 5 years with repeated hearings, adjournments, la-di-da. And so we may be underestimating. So I think one has to be very careful in thinking about and coming up with this very surprising conclusion, contrary to what Daksh and others have done, that in fact the caseload is very low. This is leaving aside all the issues of urban nature of the Delhi High Court, etc.
Thank you, sir. So that point is well taken, and audits will, of course, constitute a proportion of the workload of the court. And that's why we've tried to distinguish in the paper between what disputes are and what are disputes for the purpose of the court. Similar to land record cases, as was previously mentioned by Mr. Sanjay, land record disputes in the Delhi High Court, notwithstanding the urbanization composition, are still not a proportion of the land record dispute between parties, right? Because they've often chosen not to come to court. And if they have, this might be a lower court, right? So disputes arise, and our data set might not acknowledge the disputes between the parties themselves. Similarly, for orders, a property dispute might arise between parties. But for the purposes of the court, this was like any other case at hand, because the nature of the dispute did not lend itself to how the proceeding went through the court, again, because these were probably summarily dismissed, even if they were heard after multiple adjournments. More so, unless a senior advocate is appearing for a party, passovers and adjournments, and unfortunately there isn't a study, and probably there should be one, don't take much time of the court, simply because no one is before you, right? So if you want an adjournment, this is probably a 1 or 2 minute thing, as opposed to an actual hearing of the matter. So these 2 points probably address your concern, but again, it's well taken that we're not acknowledging all the land disputes in Delhi, as well as disputes at the Delhi High Court.
Okay, anybody else like to say something? Join here.
I think Greg Ingram, the former president of the Lincoln Land Policy Institute in Boston, has a question. Greg?
Yes, Greg.
Yeah, the question is, maybe property cases are 70%, maybe they're 30%, and so on and so forth. But the question I have is, can we stand back from this and say, what do we expect the share of cases to be? Now, obviously there are going to be some land disputes, and the question is, what do we use as a sense of what our expectations would be? One of my favorite sayings is you can't have a diagnosis of illness if you don't have a theory of health. And so the question is, do we think that these cases are a much larger share of cases than we would expect? And on what basis do we think that? If we can't come up with any kind of normative theory, we might be able to compare the share of cases with other courts and other systems and so on and so forth. And I just think that's a sort of different entry point to this problem, but it's one worth thinking about. Thanks very much.
Yeah, Karan, you want to?
Sure, thank you. So that's absolutely correct. About a year ago, Anirudh Berman, who's now with Carnegie, wrote a piece saying that it doesn't matter whether property disputes, as was then understood, constitute 2/3 of disputes in the court, simply because we don't have a benchmark of what this number should ideally be. And it's not unexpected if this number is high, given that land constitutes the largest holding of individuals in the country. And so maybe 2/3 is not a bad number. As it so happens, in the same piece he wrote that, I forget the name, but similar to the body in the United States, similar to the ICTS, suggested ICTS in India, which is an administrative support body to courts, its a corollary in the United States did a study of all contract disputes and found that 60% of them were related to property. So we know as a benchmark of comparison that in the United States, this number is similarly high. So it's absolutely correct that this number being high is probably not a bad thing. The policy considerations that come off of this are more geared towards not reducing this number or increasing, but rather how should courts deal with them? So what legislation leads to most of these disputes? What type of disputes are these? So we found that eviction and family matters are the highest. So it's fine if they're the highest, but now we know that this is the case, and probably courts should be aware of this while they're creating their cause list, listing matters, hearing them, giving judgments, so on and so forth. Another way, hopefully, again, as I've said, we aim to study other states, and probably that's another good comparison to have, that in Delhi, 36% of civil disputes are property related. This number might go up higher in Uttar Pradesh, might be lower in Maharashtra, so on and so forth. And so maybe that's another way we could compare. But again, these numbers being high or low, as you've very rightly pointed out, aren't really a cause of concern as much as are courts aware of this, and can they learn from this and better their administrative system?
Actually, I had a question for Kajal. You mentioned about the challenges of having land records in areas with where customary laws are prevalent, Northeast and Central India. You have also seen some of the practices of other countries. Do you think some of those practices can be implemented here within the laws that we have, or maybe with change of laws? What do you think?
Sir, can you repeat the last part of the question? I actually got a little.
I'm just wanted to ask whether some of the practices of other countries can be implemented here in some of these areas where customary laws are prevailing, either within the laws that we have or with a change of laws, whether it is implementable, or can we learn something from them?
So actually, the whole country, like Malaysia and Indonesia, were the major example who have conducted this exercise. But what they are doing is they are making the land record as per the community customary law demands. So if within the customary law, they have if the land is redistributive every year or every 2 years, that kind of law, then they will be given temporary titles. So they will be institutionalized at a district level or at a bigger level. But these are changeable titles within the village boundary. So if that case is seen in India, because even I don't know how many customary laws are there, but the readings that I have done, few can be done at few villages in few areas. For example, when there is a redistribution of land within the community by the social head, so that can be mapped with the temporary titles, provided that what all villages actually practice those that kind of where social head actually distributes the land, or whether or not that community itself wants to be mapped by the district of, like at a district level or at a even bigger level, because this is subjected to the willingness of the community. If the community is not willing, what the other countries have suggested is that you map them under a common parcel identifier, and then you just document what is the law practiced. So if they do not want individual land parcel, individual boundaries to be mapped, you map the community under like amount of area that it is practiced. These two kind of system that they're using, but totally pertaining to what the community actually wants to get involved into. So that is the two things that they've used, and I think that is that can be applied, but only for the readings that I have been doing, because I do not know how many customary laws are actually in place and not at all documented. So
All right, thank you. Anyone
Ramesh,
else?
I'll just add to say
anything
that
that
what
Deepak said,
Kajal and all have studied, has really brought up is that customary law areas, mapping them is not so much a technology issue as an institutional issue. That, what Indonesia tried, satellite maps, different databases, create a record, didn't work. There were overlaps, there were community resistance, it just didn't work. So it's an institutional issue, which Malaysia is showing the way, which says that first do detailed understanding of what the customs are, how does the community look at it, draw up the typologies from that, go back and field test them, structure them in a certain way. And here's Malaysia introducing a concept of qualified titles in a country which actually practices torrents. They have conclusive titles, but they introduce qualified titles which are presumptive in nature for these customary areas and saying, we're going to test them, we're going to take our time, we're going to let the communities get convinced, and all disputes we settle on them, everyone bring them on board, and then we will create the record. So it's a long-term process is the biggest learning from this, that it's not an instant quick fix. There's no silver bullet in it. You will have to take time to do this, and you will have to do in-depth work with the community to do this.
Thank you, Deepak. That was very helpful. I think we
Ramesh, may I just interject a question from Venki from IIM Bangalore that actually relates to, I guess, more to community, but perhaps also to traditional land laws. And the question in the Q&A box is to Kajal, are there conditions, political or otherwise, that make community level record keeping easier? And to some extent, this will relate to the final panel discussion on Swamitva, because there's going to be intense community level participation married to technology that hopefully is going to be the outcome of this. So either Kajal, Deepak, anybody else on this issue?
There can be no gainsaying unless you have real political commitment, you have backing, you have community, a political understanding with the community and willingness to lead at the political level. You are not going to be able to go forward with this. That is absolutely a given. I mean,
and is there a possibility, Deepak, that actually this may do more harm than good if there isn't that political commitment?
Yes, because if you try to use political technology quick fixes, if someone sells that and says, we are going to make headway with this, and we don't understand that the political has to lead by really bringing trust with the community, you will come up a cropper with this. You will create more difficulties, as in Indonesia very clearly demonstrated. In its, there was a central political will to go forward with creating that record, but it doesn't work until you have the local level trust building with the political elite.
Okay. Any other comments to wind up, because we are almost at the end of the session? Any closing remarks from anyone? Sanjay is not online.
Yeah, let me see, sir, if I'm audible. I'll just share only one point.
Yeah, please go ahead.
Yeah, sir, just to Kajal, just wanted to clarify when they were putting this dichotomy of general boundary and fixed boundary, especially in
I don't think we are destined to hear Sanjay.
Not today.
Not today. Not today. We'll have to.
This is not consistent with Goa's per capita income.
So, Shekhar, should we now come to an end, or?
Yes, and I think Deepak is going to give some closing remarks to wind us up. But Sanjay is still making valiant efforts to join us. I admire his persistence. Sanjay, I don't know if we'll be able to do much with this, but it's great to have your comments, and obviously your UT experience and your Goa experience now is going to be extremely valuable. So we really would like you to remain connected with our team and appreciate very much your guidance and advice. Before I hand over to Deepak, I just wanted to welcome Greg Ingram. Greg, as I mentioned, is an old friend. We used to work in the World Bank together. In fact, he was my boss at one point, but he was also last the president of the Lincoln Land Policy Institute in Boston, Massachusetts, in the United States, which is one of the most prominent and prolific land policy institutes in the US. And he has recently agreed to join the advisory committee of the Land Policy Initiative at the NCAER. So we welcome him not just in his own rights, but also as a member of that advisory group. And I just wanted to mention that. Back to you, Ramesh, and then I think it's Deepak who is going to close us out for this evening.
Yes, Deepak, please.
Thank you, Ramesh. Let me begin by thanking everyone who's enabled this wonderful first day of this conference, this workshop, which we've initiated from NCAER and the Land Policy Initiative at NCAER. Thank you very much, Professor Huck, for your wonderful keynote address, which was like a tour de force of every issue related to land in India. And whatever is confronting us was something which you highlighted, including what are good examples coming up in different areas and dimensions of this very vast subject. Thank you indeed for, as always, being a friend in this moment when and guiding us through this whole process of the next 4 days and highlighting what needs to be discussed. Ramesh, thank you, as always, for stepping into the breach and agreeing immediately to my request to chair this opening session of this workshop, because for us, this was so important that we have someone like you who has this vast experience of having not only been an administrative officer with experience in land, but also spearheaded and been at the vanguard of the whole idea of improving India's ease of doing business rankings and therefore addressing the whole land quality issues there. Thank you very much for giving us your time. Thank you very much, Sanjay, for agreeing to be a discussant today, because I really value your contributions. I'm sorry we couldn't hear you fully today. I have always cherished the few moments when I can hear you speak on all the occasions when I've had occasion to interact with you, because really at your young age, you have so much understanding and depth of knowledge about land that I think everyone should hear Sanjay repeatedly if they want to work on land. Grateful to you for sparing time. Sorry we couldn't really get more out of this. Thank you to both the panelists. I want to add one remark for Karan, and that is about, it seems very dramatic to say only 5% cases are related to land records, but perhaps this might be, I don't know, I'm just raising this issue for you to look at, that is it because you're using only one proxy, that is mutations, as a proxy for looking at saying, is this related to land records? So you're only looking at title. But land records in India, as you know, is far more than just title. It is about extent. It is about possession. It is about use. It is about encumbrances. And I don't know how far you are able to capture that, especially when you talk about eviction. How much of it is related to use? How much of it is related to more than just title and possession? How much of it is about possession? So how many of these cases which we are studying are actually about the lack of a comprehensive, up-to-date land record in its various dimensions? I don't know if you are able to capture that. If you are, wonderful. But if you are not, maybe you need to refine and look at this a little more. Grateful to everyone who gave suggestions to Kajal. I'm sure it will stand her in good stead as she revises and we go forward in trying to improve this paper in terms of how it can inform the Indian trajectory of taking forward the digitization and improvement of spatial records. Grateful to everyone once again for being participants today, Kala and all those who made comments today, and we look forward to another fruitful day tomorrow. Thank you very much, everybody, for being with us today.
Thank you, Deepak.
Thank you.
Thanks, everyone. Thank you.
Yeah, before we leave, I just want to recognize Peter Rabley. Peter, I didn't notice was on the call. I'm glad to see him. Peter Rabley, as many of us know him, is an incredible technologist, investor, geographer, and somebody who's led the property rights initiative at Omidyar. More recently is transitioned to being the co-founder of Place Fund, which is a whole new venture, which I think is going to take on Google head on, we think, in some areas. But it's great to have Peter with us. And Peter is also a member of the advisory committee for the Land Policy Initiative at NCAER. So Peter, do you have a word or two before we sign off?
No, I'm realizing that I stand between everyone and moving on. So just that it's been worth getting up early for. And thank you very much for entrusting me to be part of the advisory panel, and look forward to engaging with you all. Thank you, Shekhar.
Thank you, Peter. Ramesh, with your permission, shall we close out this session then?
Yes, absolutely. Thank you. Thank you, Shekhar, and thanks, everyone. Thank you.
Yeah, and I'd like to really thank the entire Land Policy Initiative team. You see the 5 papers by the team. Individual authors are not named because this is really a community effort led by Deepak and Shom. And I want to thank them both for really being the powerhouse behind this whole India Land Policy Forum, and of course Anika Kapoor, without whom this would not have been possible. So thank you all. Thank you, Shashank. Thank you, Professor Gupta. Have a good evening, and we'll see you tomorrow at 5 p.m. 1700 hours Indian Standard Time. Adjust your clocks in other zones. We look forward to another exciting day tomorrow. Thank you. Bye-bye.
Thank you all.
Good night.
Bye-bye.